Welcome, everyone. My name is Ted Barbieri. I'm on the faculty here at Albany Law School. We are really excited about the First Mondays program and to continue it. Here is for new attendees, and I see a lot of familiar faces in the participant list, which is great. For new folks, First Mondays is an opportunity to talk about business events, political events, and other goings-ons through a legal lens. This is the second event that we're doing for the current academic year, and we will continue the program as we have sort of hot topics that come up. Obviously, there's a lot going on in the world these days, and we're I think rightly so, consumed with what's happening tomorrow and what's happening with early voting. But we're taking a moment to focus on a number of events, and Professor Reyhan in a moment is going to run through our agenda. We've got a packed agenda today. Main thing is to have a respectful conversation. We don't all view things the same way, but that doesn't mean we can't talk about them. So that's really the idea that motivated First Mondays. We started last academic year, and we've been continuing this year. We did talk about voter disenfranchisement in October and some issues that we hope were useful and entertaining. I'm going to turn things over to my colleague on the faculty, Professor Pat Reyhan, to talk about our agenda for today.
Thanks, Ted. This is season 2, episode 2 for all of us Netflix people, and we have a really packed plot line. In this one, we're going to look at 3 different business or business-related topics. As Ted said, we decided the day before election, there's probably enough noise going around on election things. It might be nice to take a 1-hour respite and talk about these subjects. So we have subjects today that touch on national security, on personal privacy. An overarching theme of the 3 subjects we'll look at today is the incredible power of the federal government in the role in both civil and in criminal settings, in the role in essence of the plaintiff prosecutor. And then in the case of Purdue Pharma, we'll see how the government in the role of the prosecutor of the plaintiff can settle cases in a way that may or may not be fully satisfactory to the public, just as they can bring cases in that way. So we're going to start with the executive branch's efforts to basically bar TikTok, bar the downloading of the video app sharing app TikTok, was to be November 12th. I'm sure we'll talk about sort of what happened last week. Then we get to the issue of the Justice Department's antitrust action, one of the biggest ones in 2 decades, against Google, an issue that I'm sure we'll hear implicates Apple as well. And finally, we'll turn to the Justice Department's global criminal and civil settlement of all of the claims against Purdue Pharma and the settlement of some of the claims, certainly the civil claims against the Sackler family. So let's get started. Ted's going to, just so you know, we're going to do TikTok first, then we're going to do Google, and then we're going to do Purdue in that order. So about 15, 20 minutes on each. Ted, take it away.
Great. So with us, joining us from the DC office of WilmerHale is David Horn, who's a special counsel and he's an alum of University of Michigan, go Blue. Sorry about your loss this weekend, and BC Law School, and has been at WilmerHale, for a number of years now. And so, Dave, from what we've talked about before, your role largely in your practice involves advising industry on regulations, particularly with dealing with Department of Commerce or other executive branches. Take us through here. So, like, what was the Trump administration trying to accomplish with? I think we've heard a little bit about the headlines with respect to TikTok. Take us through the law a little bit about what the administration was using to apply to TikTok to force the merger or sale from your perspective.
Sure. Thanks, Ted. So there are, first, thanks for having me. It's great to be with this audience talking about this very interesting issue. As you said, Ted, my practice focuses on on, among other statutes, the International Emergency Economic Powers Act, or IEPA. And IEPA is a statute that you all may have heard of. It's been in the news more and more, in particular because this administration, as well as the last administration and the one before that, have been using IEPA more and more to achieve foreign policy aims that are not being addressed, or in a given administration's view, are not being adequately addressed by Congress. IEPA is a 1970s era statute. It is a post-Vietnam statute that was actually intended to limit the authority of a president to act in response to a national or international emergency. Although, as a lot of these statutes tend to be, has been used and abused over time in ways that Congress may not have anticipated. And so, for example, on questions like whether President Trump had the authority to demand that Mexican immigrants to the United States or workers in the United States from Mexico could have their remittances taxed, or whether funds could be diverted from one federal program to another to build a border wall. Those kinds of questions often turned on an interpretation of IEPA and whether the president had sufficient authority under IEPA to do those things. So here with TikTok, I think it's also important to understand that this is part of a broader set of US policy concerns about China and about the Chinese Communist Party, and the ways in which the Chinese government competes with the United States through technology competition, through sort of hard and soft power. And those concerns, of course, also predate the Trump administration. But when it comes to TikTok, there is a particular concern that US user data could be used and abused by Beijing in ways that could threaten national security. And when you read the August 6th executive order, which was issued by the president pursuant to IEPA, it describes some of those concerns, right? It would be a concern, for example, if a Chinese company that may not have the appetite or the legal right to deny a request by the Chinese government access to its user data had U.S. service member data, or the data of federal employees, including intelligence officers, or other sensitive types of users. So that has been the primary concern, and has actually been reflected in recent cases under another statute, which I'll mention, which is the Defense Production Act, and CFIUS, the Committee on Foreign Investment in the United States, which was created pursuant to executive orders, in this case issued under the Defense Production Act. And CFIUS has been concerned for many years, and just for you all who may not be familiar, CFIUS is an interagency committee and a regulatory process by which the federal government can assess foreign investments in U.S. businesses that raise national security concerns. And so one of the concerns that has been developing over the last decade or so has been a concern around when a foreign company may gain access to very valuable data about U.S. users. And so here you have these two statutes actually converging. You have the executive order on August 6th that authorized the Commerce Secretary to identify new prohibitions involving TikTok by users of the app. And we can come back to what those are and where things stand now, and the litigation around that in a moment. But then you also had a week later, on August 14th, another separate executive order, this one pursuant to the CFIUS statute, which required that ByteDance, the parent company of TikTok, divest its U.S. assets in TikTok and a company called Musical.ly, which has been acquired previously, that got folded up into TikTok, to divest those assets because of the national security risks that the administration identified in connection with the acquisition and the Chinese company's control over the data that was being vacuumed up by U.S. users, millions and millions of U.S. users of the app. So I'll pause there and see where you want to go with the discussion. I'm sure others have a perspective as well, but it is an interesting convergence in statutory authorities, and in some ways is new and novel. In other ways, is part of a trajectory that goes back decades in terms of executive exercise of these statutory authorities.
Yeah, very interesting. Thanks for taking us through the statutes. I have one question, but I'll just say for students, especially, we've got 39 people participating out there. If you want to either raise a hand or put something in the chat, we can get your question to our speaker. We're going to bring in Professor Harrington in a moment. I guess just one question, like how much precedent is there for this type of effort? Is this normal?
No, I mean, I am, to the extent that there are IEPA experts wandering around Washington, D.C., trying to make money by interpreting IEPA, I'm one of them. Having said that, the executive order issued on August 6th has no real precedent. It was issued under IEPA, but is very different from a standard IEPA authorized executive order. Most executive orders and most of the authority that has been carried out under IEPA has been for sanctions programs, the establishment and implementation of U.S. sanctions programs. So for those of you who have heard of, U.S. sanctions against Iran, or U.S. sanctions against Russia, or U.S. sanctions against Syria or North Korea, counterterrorism sanctions, those sorts of things, much or all of those sanctions and those sanctions programs have been established pursuant to different executive orders issued by different presidents over time under IEPA. And most of those, nearly all of those programs are administered by the Treasury Department, with some administered by the State Department as well. The executive orders on August 6th, one having to do with TikTok, the other having to do with WeChat, were brand new. They were completely novel. The structure of them was new, targeting specific companies in the way that these executive orders targeted TikTok and WeChat in particular was unusual. I'm not going to say completely unprecedented, but unusual. And the fact that it delegated authority to the Commerce Department was also somewhat novel under IEPA. Again, most of the authority for implementing IEPA falls to Treasury or State. The one wrinkle here, which I'll mention, is that back in May of 2019, there was a separate executive order that President Trump issued that was designed to address vulnerabilities in the information and communications technology and services supply chain. And this was seen primarily as an effort to keep Huawei and some other Chinese telecommunications companies' equipment and technology out of U.S. Telecommunications infrastructure. The August 6th executive orders weren't issued. They mentioned that executive order. They're trying to build on that framework, but all of that also lives under IEPA, and all of that is new as well. That May 2019 executive order was also a novel application of IEPA. The regulatory process implementing that EO is ongoing, and so we don't have any law yet from it. But yes, this has been in some ways an implementation of the statute that is novel relative to past implementations.
Yeah, that's great. And I guess maybe just finally, so we have a ruling coming down at the end of last week. So where are we right now?
So one of the really interesting aspects of IEPA, and something that I spend a lot of time with in my practice, is there is a limit. When Congress passed IEPA, it limited, in certain respects, the grant of authority to the president. And one way that it limited the grant of authority was by, and actually this has been amended over time, so I shouldn't say that it occurred all at once when the statute was passed into law. But over time, Congress, once in 1988, once in 1994, Congress has amended IEPA, and those amendments, one of those amendments, say that the president, in exercising his authority or her authority under IEPA, cannot prohibit or restrict the import or export of information or informational materials. This is known colloquially as the Informational Materials Exemption, or you might hear it referred to as the Berman Amendment. And so this obviously is very interesting because, if you are a social media company, for example, and you have on your platform terrorist organizations or Venezuelan or Iranian government officials who are on Treasury Department blacklist, can you provide that service, provide that platform to them if all they're doing on the platform is importing and exporting information or informational materials? So it's become, in the age of social media, a really important aspect of IEPA, and there has been a lot of litigation around the extent of the president's authority under IEPA when it comes to information or informational materials. So obviously here, the Trump administration walked right into that mess by using IEPA to go after TikTok in particular. And so both cases, there was the District of Columbia case. My former colleague Carl Nichols, who's now a judge here in Washington D.C. in the federal court, issued the ruling in that case. That had to do with one of the prohibitions against TikTok, and then the case in the Eastern District of Pennsylvania late last week that you referred to had to do with those that are due to come online on November 12th. In both cases, both decisions, the judge relied heavily on the informational materials exemption, found some serious flaws with the government's theory that it could restrict the information that is exchanged on TikTok because of the limitation in IEPA. And as we sit here today, none of the there's two preliminary injunctions. One with respect to the first prohibition against TikTok, and then the other with respect to the rest. In the WeChat litigation out in California, the government has sought stays of those preliminary injunctions. It's failed in the district court. It's failed at the Ninth Circuit. It's a really sticky issue, and especially because it has this obvious First Amendment overlay, and that was, of course, the genesis of the Berman Amendment in Congress, trying to ensure that that First Amendment principles were reflected in IEPA and constrained the president in his exercise of that authority. So as we sit here now, by all means, download TikTok, use TikTok, get all your TikToking in. Obviously the election tomorrow could change the administration's posture when it comes to these prohibitions generally, and certainly the litigation. And we'll see how the litigation goes. Obviously, a lot of companies, not just TikTok and WeChat, have a great interest in seeing how the informational materials exemption and this provision of IEPA is interpreted in the course of this litigation.
I love to subtitle First Mondays as an opportunity for students to find an upper level writing requirement topic. So, we certainly have a ton of info and obviously a packed agenda. Dr. Alexandra Harrington, our colleague who teaches international law, wanted to add a couple comments to the TikTok conversation. So please, Professor Harrington.
Just quickly, very quickly, because that was absolutely brilliant. And I will admit, I still have to learn how to use TikTok. My niece is starting to teach me, but I still have yet to actually do it. So we'll see. Maybe I won't get a chance. You never know. What I just wanted to do is give a quick perspective on, in the context of kind of the international realm, how other countries have handled TikTok, because we have started to see an uptick in how there are kind of negative reactions to TikTok. And our concern tends to be security and privacy, which is also the case in India. And we've seen India thus far as a very durable ban, and they did put a ban in place in June. Although there's been a lot of criticism, especially from people who feel like because of COVID, they've only been able to connect through TikTok and through social media. And also to point out that in the Indian context, they actually targeted about 85 other Chinese-based apps. So it wasn't just one or two, it was a whole genre. And many people, not only those concerned about kind of narrowly tailoring something or being too narrowly tailored in scope, but also those who are concerned about privacy issues think that having just a focus on TikTok or WeChat or few tends to kind of undermine a lot of the other concerns that you come up with privacy issues in China. But India has had a very durable ban since June, and it's been going reasonably well. Several other countries have attempted to implement bans, not based on security as much as public morality. So both Pakistan this year and Indonesia in 2018 tried to ban TikTok because of perceived immorality or indecency associated with some of the activities on TikTok. Many of these just had to do with dancing and mixing of sexes, etc. There was one instance where briefly there was a concern about child pornography or potential for child pornography. In both examples, the ban went into effect and then was rapidly removed. So in Indonesia, this happened quite quickly. In Pakistan, we saw in the beginning of October, there was a ban put in place, and 10 days later, it was taken off. So what is an interesting dichotomy to think about for US purposes, as well as internationally, is the justification for the ban. Because it does seem that if the justification is security and privacy based, it tends to be much more durable, and the public actually tends to be much more willing to go along with it. If it is something that is content based in terms of indecency or morality, it does tend to seem a lot more short-lived. Of course, this can also be more easily remedied by TikTok or any corporation by putting restrictions in place, and they certainly have. The other interesting thing just to bear in mind, one of my perspectives, having spent the past 2 years in Canada as a Fulbright research scholar, is the example of Hawaii and in Canada, and how that has kind of had a chilling effect on those who would try to handle in some way any type of Chinese technology or those responsible for it. So briefly, what happened was that the US had wanted to try a high-level Hawaii executive who was in in Canada. She was apprehended in Canada, and there was an extradition attempt that Canada was willing to enter into with the US. China then became very adamant that this should not go forward, that the charges were not appropriate. And in the meantime, several cases of Canadians in China who had been on trial for very low-level drug offenses got bumped up to being capital cases and sentenced to the death penalty. And the inference was that this would happen more often unless something changed. So while we understand the concept of how we can see better TikTok, et cetera, justifications, we also need to think about this against a backdrop of what the larger international ramifications are, which is one thing I just wanted to mention because it's such an interesting perspective that we often don't talk about. I don't want to take any more time, but I did want to raise that. And obviously, if anyone wants to talk about that afterwards, feel free, or track me down by email. You all know where to find me, all of you students, and many of you do. So thank you.
Thank you, Professor Harrington and Mr. Horn. Thank you very much. And we're going to move on to Google. We'll do questions at the end just so we can get through everything. But please, all of you who have questions, keep them in mind, put them in chat, whatever you like to do. We will get to them. So thank you to you both. It's my pleasure to introduce Ted and Alex's colleague, Rob Heverly. Professor Heverly is an expert in many things, including intellectual property law and technology. Actually runs a course here, or has a course here called Drones. So he's a perfect person for this discussion. Rob, Dave mentioned that one of the issues or perhaps the driving issue in the TikTok case, if you will, small c case, was concerns about user data used and abused. User data used and abused. And I thought, well, what a great segue to talking about the Justice Department and its antitrust action against Google. So it's all yours, Rob. Tell us what we need to know.
Well, I guess I'll do this sort of, thank you, by the way, for inviting me to participate.
Thank you for accepting.
Some fascinating topics here. So I'm going to ask everybody to get their little hand raising thing ready, because I'm going to do the professorial thing and ask a couple of questions. And so how many of you use Google to do searches? Okay, so maybe I should do it. All right, so the hands all show up over there. So that's pretty much like all the people, right? How many of you use Google to search using your voice? Okay, so some people with the Siris and the Alexas. How many of you use Google through Apple devices? Okay, so lots and lots of people, thank you very much for playing along, use Google. How many of you click on Google ads? I'm just watching the hands go up there, and some people who are on screen are holding them up. So not quite as big of a number. But there we have the crux of what the Justice Department is claiming that Google does and has done over time. So it's probably helpful first to talk a little bit about what the kinds of claims are here. So this is a claim against Google for anti-competitive behavior. And so we refer to that oftentimes as monopolies, but the word monopoly literally means there's just one option, which there obviously isn't. So we use that within antitrust law. And I'm not an antitrust lawyer, but I do know tech, and I know the history of antitrust is used in Microsoft and other areas across AT&T and others across sort of the history of technology. And so courts ask if a firm that is accused of an antitrust violation has monopoly power in any market. So that's a study of what's sold by the firm and alternative products, typically looking to see if the firm accused would lose customers if it attempts to raise prices, which is kind of a weird thing here because we don't really have prices. We'll see in a minute. And then if they find that there is monopoly power, they ask if that position, that leading position, that monopolist position was gained through improper conduct, something merely better than having the better product or some sort of historical accident or some sort of innovation that was then built upon, or the typical efficiency things in marketplaces like better management, better efficiency with workers, et cetera. So what is market power? Well, generally courts agree that anything below 50% of sales in a particular product or service, it might have a limited geographic range, is not going to be monopoly power. So if you're below 50%, you're not a monopolist. If you're above that, some courts require even higher percentages than 50%, and some are happy to start looking at your behavior if you control more than 50% of the market. So the thing that we have is if you have a monopoly, if you have significant, the word that the Federal Trade Commission uses is, the phrase is significant and durable market power. So long-term ability to raise prices or exclude competitors. That's what we're talking about. This is what the Justice Department is saying that Google has. Google has this monopoly power. So I'm gonna try here to, they've illustrated this throughout the complaint, and I'm going to see if I can share this here. But now what I'm sharing isn't showing up on my screen.
We see it.
Okay, so you see here this chart, right? So let me make that a little bit bigger, but hopefully not too big. So you can see the chart here. This is search engine US market share in the US 2009 to 2019, and the red is Google. And down here, we've got Bing, Yahoo, which in 2009 is bigger than Bing, DuckDuckGo, which actually doesn't show up on any of these here, but the Justice Department has included it throughout its complaint. And then other is the gray that sometimes appears as you go along. So another illustration they have is this one here. So they've done a pie chart as well. This is mobile search engine US market share. So the first one that we looked at here is search engine US market share, and they do break that out, and they pay a particular amount of attention in their complaint to the kinds of things, the kinds of ways that you do searches. And so they talk about desktop computing searches in your web browser through Chrome, and then they talk about them through mobile devices. And you can see here, computer search, Bing has 12%, and mobile search, Bing has 2%. And so part of what's also sharing that again. So part of what is going on here is we're talking about how Google has gotten there and how it stays there. Being a monopoly in the United States is absolutely just fine. You can be the market leader. You could have 100% of sales of the product in your marketplace, and that is fine. The thing that's not allowed is taking inappropriate measures to maintain that position or to gain that position. And so those are the kinds of things that aren't allowed. So what are we looking at in terms of this particular complaint? The complaint is primarily focused on general search services, search advertising, and general search text advertising. Those are the three markets that the Department of Justice has identified. And they're arguing for three different types of injuries: injury to consumers, injury to advertisers, and injury to competitors. So they're saying that Google's behavior in these markets has led to these kinds of injuries. So what do they allege the injury to consumers is? Well, that as a consumer, you have to agree to Google's privacy terms, which are invasive. And as a tech person, I'd agree they're pretty invasive. They like to track you as much as they can. Their goal being to learn as much about you as they can, to sell you advertising that you will be interested in seeing so that you will buy stuff, so that advertisers will value advertising through Google, and then Google will make more money. According to the Department of Justice, American consumers are forced to accept Google's policies, privacy practices, and use of personal data, and new companies with innovative business models cannot emerge from Google's long shadow. And so one of the dangers, one of the things that we don't like companies with monopoly power doing is trying to exclude others from the market by using their contractual arrangements with marketplace participants. And so that's an injury causes injury to the consumers here, because you don't have any alternatives, because the agreements that Google has with phone manufacturers, with people like Apple, to make Google search the search engine, the default and preset search engine, mean that other search engines can't even get off the ground. You can't find them, you can't have them. Other options don't work because they're too big. And the Justice Department uses a subscription-based search engine that couldn't even get off the ground because nobody would include it. So the idea was you wouldn't have ads, you would pay, and your payment would support the search engine. The injury to advertisers is that they have to pay to reach the consumers at rates that they wouldn't have to pay otherwise if there was competition in the marketplace. And then this injury to the competitors as well. So we're hurt because we have to agree to their terms. Advertisers are hurt because they end up paying more money than they would if there was competition in the search marketplace for advertising, and competitors are injured because they can't get off the ground. So in terms of what they've alleged, they talk about different pieces of this. And one of the primary ways that they talk about it is in the way in which Google does its business with, say, phone manufacturers and similar kinds of distributors of technology, where it uses these things called anti-forking agreements. So that if a phone manufacturer wants to run Android, and this is a really sort of geeky, interesting part of this, is that the phones, the Google phones, like mine, they run Android. And Android is an open source operating system for phones, unlike the iOS system, which is completely locked up. Nobody else can manufacture using the iOS operating.
Uh-oh. Well, that's technology, eh? Rob, you just froze on us. Let's give him a minute while we're giving him a minute.
Other kind of
Here we go.
system. What's that?
Oh, you froze for a minute, but you're back.
I've got two kids who are also in school today from home, so that could happen here and there depending on how the local cable traffic goes, I guess.
No worries, you're back.
So part of what we're talking about is that Google engages in these anti-forking agreements and says, if you're going to distribute an official Android phone and get the benefit of the Android updates, and all of the work that Google does on the operating system, you either have to go along with the compatibility definition document, which is a technical standards document, which keeps you from changing Android too much, or the Android compatibility commitment that was new as of 2017 because the EU started to investigate Google for anti-competitive behavior. So the compatibility definition document essentially was harsher, and you couldn't distribute devices that were even capable of running forked Android. Or you weren't supposed to do that knowingly. That would be a violation of the agreement. Well, the ACC is you can do that, but you're not allowed to distribute forked Android. And forked Android is just different Android. So a fork of Android is the Amazon operating system. So they have all of their reader devices and their tablets and their Amazon TV devices and all those things. And those all run a version of Android. And because it's open source, they're allowed to do it. It's forked, which means it's not compatible with a lot of the stuff that Google does. And so what Google says to its manufacturers is you can't manufacture and distribute devices that have the forked version because we're going to maintain control. And so that's part of what the Justice Department is complaining about because they say that then ties Google with its search engine into the device right from the get-go. And so when you get your phone, you're going to be able to search on Google really, really easily. It's going to pop up. I've disabled whatever the audio searching on my phone is, but still, if I press the screen the wrong way, it comes up and asks if I want to enable it. So they're aggressive in trying to push their versions of the different search engines. So the Justice Department is arguing primarily about these forking agreements, how they interrelate with what are called pre-installation agreements, which is how it ends up being the preset default in your phone. But Google does all of this. Why do the manufacturers do this? Why does Apple do this? Because of revenue sharing. Google gives them a lot of money, a lot. Apple gets a nice chunk of change from Google every single year. And so the Justice Department, we said we want to stay away from election stuff, but I don't know anyone who's willing to say that this isn't a political document, especially in its timing. And the general consensus in antitrust folks is that it's not a particularly strong complaint for a variety of reasons. One is there are tech companies that probably have as strong a monopoly, if not stronger, who are behaving much worse, and that's Amazon and Facebook. Amazon in particular is using its market position to do market research. So it watches, somebody comes in with a great new product, Amazon watches it, sees it selling, and then suddenly there's an Amazon version for sale. And maybe even shows up higher in the rankings. Facebook likewise is doing a lot of stuff that's considered in antitrust circles a little bit doubtful in terms of whether it would get them into trouble or not. So Google has some of this, but doesn't necessarily have so much about it. The second thing is Google search is really, really good. And a lot of the other searches aren't particularly good. I find Bing to be less acceptable. I wish they would have given it a different name. I'm not quite sure who names a product these days Bing, but okay. DuckDuckGo is good, but DuckDuckGo is building its own database. Yahoo, for example, uses the Bing database. So DuckDuckGo's out there trying to build its own thing. That takes a long time to actually build a compatible or a competing database. And DuckDuckGo is selling as a privacy protective search engine. People are using it for that, and it is growing. Okay. How many of you are on the internet today using AOL? I see one person willing to claim that they're using AOL, one of my tort students, no less. So we don't use that, right? But in 2000, we thought AOL was a monopolist. That's what we thought, right? So, and then what happened? AOL is pretty much gone. I mean, it's anachronistic when somebody sends you something from an AOL email. So one of the arguments is that these things will reset themselves over time. And in tech, that time is actually not that far or not that long. And so the DOJ is going and trying to force some of this. Now, they did a similar thing to Microsoft in the late 90s. There's a very famous, you can Google Bill Gates's deposition online on YouTube from that, where he has all these memos that he's written, and in the deposition he's trying to pretend like he didn't really write them, I guess. That's probably too harsh, but he tried to distance himself from them and it didn't work. And they were engaging in anti-competitive behavior. And in the end, it wasn't a horrible outcome for Microsoft, but their business practices really changed and supposedly enabled companies like Google to come into existence. So it'll be interesting to see this as it goes forward. It'll be interesting to see whether it becomes more politicized if there's a change in government or if there's not a change in government, and what the status of it is at that point. So that's Google. Thank
you, Rob, very, very much. We'll move to our final subject. Ted, you want to take the intro on this? And then again, we'll come back and open up to questions on all three subjects.
Yeah, so here we're fortunate to have an Albany Law School alum and a repeat guest to First Mondays. CJ Kempf is the Rensselaer County attorney and joined us last academic year to talk about the opioid crisis and how it's impacting counties and the litigation specifically related to the counties are bringing across the country. So CJ, you shared some insight over email very briefly, but so how does the proposed settlement that Purdue Pharma is proposing viewed by your client, Rensselaer County, our friends across the river? And you're on mute, so I need to unmute you, or you can unmute yourself. And if you're, let's see. Yeah, if you're calling in, I think it's a *6, or maybe I can do it. Maybe Jeff could give us a hand if you're there.
I think I got it, Ted.
Excellent. Perfect.
Sorry about that, Ted. Thanks for having me.
No worries.
I wasn't sure if I was going to get a few calls in between while I was on Zoom. Thanks for having me back. It's been a long road for Rensselaer County. So we filed our complaint in 2017, and here we are at the end of 2020. So we're, on a county level, and as the same with all municipalities, looking for it to come to a head and resolution sooner rather than later. So I would say overall, this is a positive development to push the ultimate whatever is going to be settled upon forward and toward an end game. I think we're still a long way off from an end game, but this was a very significant step. I think from all the plaintiffs' viewpoints to get the Department of Justice bankruptcy claim off the board and put a number on that claim, and to allow the bankruptcy process to move along towards hopefully a final settlement. So we did view it as a very positive sign as far as pushing along to resolution sooner than later, but sooner is not going to be all that soon. But this was viewed as a positive development, no doubt about it. Just to give the folks on the call just kind of a brief overview. Purdue Pharma has been fighting on multiple fronts over the years. Department of Justice investigation, a large federal case in Northern District of Ohio, now in bankruptcy court in Southern District of New York, and through state courts throughout the country. And one of those state courts obviously is New York litigation. And in Rensselaer County is a plaintiff in that New York litigation. In addition, we're a creditor in the bankruptcy matter that's pending in the Southern District, and we were a member of the negotiation class in the Northern District of Ohio until that was that class was recently denied. But the DOJ signaled that something was coming to a head in July when they filed a claim in bankruptcy matter. Usually DOJ, unless they're ready to move, they like to stay quiet. So there was a little bit of a signaling in July when they filed their claim in bankruptcy court. And they have, reached a plea agreement recently and a settlement agreement on the civil side with Purdue Pharma and the Sackler family who owns Purdue Pharma. Just quickly, just briefly, under those plea and settlement agreements, that Purdue Pharma is going to plead to 3 felony counts, and there's going to be a $2.8 billion civil settlement that'll go into the bankruptcy matter, that'll presumably be available for municipalities to access, but that still remains to be seen as to what the terms around that $2.8 billion number will be, and who that will be distributed to.
Right, so still up in the air to see how exactly Rensselaer County, as one example of a county who has had significant impacts of the opioid crisis, still remains to be seen how the funds will actually impact the county, but some hope in the same vein.
Yeah, Ted, I do think that the municipalities will see some money out of this. I mean, just for comparison purposes, you know, the tobacco settlement, which is widely talked about as the opioid litigation is going on, that was a $250 billion national settlement. I don't think we'll get anywhere close to that on the opioid litigation. I don't think we'll be close. And with Purdue, the overall numbers being discussed are somewhere in the range of 8 to 10 billion, and the DOJ settlement was only part of that 2.8 billion, it looks like. So you divide that up across the country among thousands of municipalities. I think the number will likely be very small at the end of the day for each municipality, and just like I said, the tobacco settlement was 250 billion nationwide. Rensselaer County received 34 million in the tobacco settlement. I don't think we'll receive anywhere close to the 34 million in the opioid litigation settlement, but long way to go. There are negotiations, ongoing with the New York State municipalities and the Attorney General and the state as to how much the state would have control over and how much the municipalities will control over. So that's an ongoing discussion in the background that isn't heavily reported on at this point. But that is a significant event that's an interesting event that's ongoing as to eventually, when the pie gets cut up for New York State, how that will be divvied up between municipalities and the state.
If there's any other theme to draw from these 3 examples, TikTok, Google, and Purdue Pharma, there are tons of ways for to-be lawyers and practicing lawyers to get involved in complex issues with respect to government regulation, antitrust, international trade, as well as with respect to the pharmaceuticals. We have a couple minutes left. We've got a number of students joining us, some alums as well. So with some time to engage with our guests before we wrap up. If anyone would like to sort of pose a question or take us in a direction.
I have just a quick comment while people are thinking and coming off what Carl was just speaking about. One of the interesting things about this proposed settlement, the bankruptcy judge has to sign off on it, is that Purdue Pharma will be converted into a public benefit corporation going forward. And interestingly enough, we'll be selling, one of the things it will be selling is the drug that's used to I don't remember the name of it right now, that's used to counteract overdose symptoms and that sort of thing.
Very interesting development.
Narcan, thank you.
Okay.
So I guess barring additional questions, shall we thank our guests? So thanks so much to our guests for joining us. Thanks, Dave, Alex, Rob, CJ. Thanks so much for spending your time with us on a first Monday in November. Appreciate all students participating and alums as well. Stay tuned as these issues develop further, and stay tuned for future First Mondays conversations as we move forward.
Mr. Schmidt has a question.
Hi. I guess, I don't have a super specific question. I just, I had heard some criticism about the deal with the pharmaceutical company, and I was hesitant to jump in because I haven't really dug in and gotten a good understanding of the details. But if, we're just kind of ending early, I guess I might as well put it out there and see what the reaction is. And it seemed like, I guess the criticism I heard was, it seems like the individual people, the Sackler family, got to sort of pillage the company and walk away with billions of dollars, and that the fines are then saddled on the company itself, which, as Professor Reyhan mentioned, is being turned over to become a public entity. And it's almost like the crooks get to take the bags of money and walk, and leave this kind of liability-ridden entity that's now going to be a public burden. And I don't know, like I said, if that's really inaccurate. That was what I had heard someone sort of characterize things as, and I was curious, how accurate, or if at all accurate, that sort of assessment is.
You want to take that, CJ, or you want me to?
Yeah, I'll give you my 2 cents on that. So a couple things around that. The plea agreement, although the Purdue, the corporation or the limited partnership is the one pleading to 3 felonies. The plea agreement expressly provides that it does not preclude the DOJ from going after any of the owners or Sackler family. So they do not have any sort of relief from criminal charges in the future. So that is a significant overhang that they were not able to negotiate in this settlement, which is significant. So yes, there are lots of critics, in particular, 20 or so attorney generals throughout the U.S. that have been critical of the settlement. But I would say that is something significant that DOJ did not concede or give up on, and the Sackler family was not able to negotiate to include as part of the settlement. And listen, I've had clients who, they have that overhang of charges pending against them. It's not pleasant, no matter how much money you have in your pocket. So I would say that's a significant development that was expressly included in the settlement agreement, that the DOJ may pursue, has the right to pursue criminal charges in the future against any of these individuals. So I think that is significant. People, there was various criticisms about the dollar number. I think, largely, there's not, when you get right down to it, you're talking billions, but it's not really all that amount of money in order to remedy the damage that was done. So I think that's a bit of posturing when people come out on the numbers, because there really just isn't a lot of money there, I don't think. But I do think that that's significant, that there was no give up by the DOJ on the individuals.
I agree. I was going to mention the same thing. The settlement includes a civil settlement against the Sacklers, not for a huge amount of money, but it did leave open the criminal action against both the Sackler family and some of the higher employees of Purdue Pharma. So the Justice Department may use that a little bit, one of those actions, as leverage against the other, and that sort of thing. I think the biggest thing, Mr. Schmidt, that has led to this outcry is when you compare, CJ indicated, when you compare the amount of money that was part of the tobacco settlement with the amount of money that's part of this settlement. It's now, you had multiple defendants in the tobacco settlement, but still it sort of pales in comparison, which I think somewhat fed the concerns that you described. And thank you for the question.
Thank you for the answer. I appreciate it.
One thing to mention to all of you before we wrap this up is we get these topics sometimes from our own heads, but as often as not from all of you, from those of you who are interested in First Monday. So if there's topics that you'd like to have addressed in the next few months, please absolutely let us know. We stayed away from the election from tomorrow, except as it was reflected in the issues of today, just want to mention there's a town hall on Thursday in which we'll all get together and see where we are on Thursday and see how we feel on Thursday. So just wanted to mention that as well. Ted, you want to tie us out?
Yeah, I think, just right. I appreciate the time that our presenters have taken from their days and to share their expertise in the particular areas. So thanks very much for that to each of our guest experts. Thanks to all of you, both students and alums, staff, faculty, for joining and participating in the conversation. Let us know what you want to talk about in the future, and we'll follow up with a future installment of First Mondays very, very soon. So thanks everyone, and be well.